Hello YouTube, I am Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Now, we have a question here from YouTube user Voiceful, posted 5 days ago. I apologize for the turnaround time. Honestly, I think we have other videos answering this question, and I would generally tell people, encourage folks, listen, you got to go back to the back catalog. I can't watch the videos for you. There's a search function on the channel. Got to use the search function, look to the catalog. We make the videos. We can't watch them for you. But here, Voiceful asked it in a way that I thought was a little different, and I thought it had value, and this comes up a lot. So I want to listen. If I already made a video on this topic, I'll make another because I think maybe there's two videos. There's more chance it helps somebody. Maybe I'll say something different that helps somebody. Maybe somebody will see this video, not the other video, and that'll help somebody. So good enough. So YouTube user Voiceful asked us, I saw this video before signing a complaint. Voiceful, I believe, means a complaint with the EEOC, the Equal Employment Opportunity Commission. Believing in humanity, that my case would go through differently, and sure enough, I was immediately given a right to sue letter. I'm pretty saddened. What happens now? Okay, so Voice will post that on our video entitled, "The EEOC did not even ask me for a rebuttal or schedule a mediation. What does this mean?" And what happened was what often happens with the EEOC. They gave out a right to sue letter. This happens to most people who file with the EEOC. Generally speaking, if you do not settle your case in the EEOC, and if you are not a federal employee, and because the federal employees have their own special EEOC process, generally speaking, your case is just going to receive a right to sue letter from the EEOC. We have videos about the numbers on this. We have a lot of information on this page about this. You might say, well, what does the EEOC do then? Great question. Great question. I mean, they promulgate some rules, and sometimes those rules have real value to employees. So I'm not going to say they're worthless. And the EEOC definitely has some employees who are amazing. I will always thank the sun, the moon, the stars for Deborah Reich in the Manhattan office, who I think is one of the greatest mediators I have ever met. She is also, I believe, an EEOC employee and is amazing. Truly. But on average, the EEOC's employees are mid, as the kids might say. Mid at best. Okay? A lot of times, cases don't even get read. You can have conversations with investigators. You can be like, well, like I said in the rebuttal, blah, 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 blah. And they'd be like, what? Sure, yeah. You're like, well, yeah, and I also said in the rebuttal that so-and-so pulled a gun. And they'd be like, what? Really? And I'm like, no, not really. You didn't read the rebuttal. A lot of them don't read. They don't even read what's filed. That's sad. But the reality is they're just going to issue a right to sue letter. And it doesn't matter from their perspective necessarily if they read or don't read, because it's probably not going to change anything, because if the other side doesn't want to come to mediation, right? If you or the employer don't want to go to mediation, at that point the EEOC is like, what would we do? Right to sue letter, right? And the right to sue letter gives you access to federal court with your workplace discrimination or your workplace sexual harassment claims. So, Voiceful, when you're asking us what happens now, the day you receive your right to sue letter starts the clock. You have 90 days from the day you receive that letter, and confirm that it's from the day you receive it, not the date dated. In New York, it is from the date of receipt of that letter. And I believe that is true in most, if not all, jurisdictions. But I could see some federal court somewhere having a different case law on that issue. So, just pay attention where you are, that is the rule. From the date that you receive it, you get 90 days. And let me assure you, if you let that 90 days run out without filing something in federal court, there is a very, very, very good chance that your federal claims for workplace discrimination, workplace sexual harassment, or related retaliation could very well be extinguished. Does not mean your entire case is necessarily extinguished. You might have state or local law claims that survive. You might have unrelated federal claims that would not pen through the EEOC and so would not be extinguished by your right to sue letter. I'm just telling you, the claims that went through the EEOC, If you don't get this filed within the 90 days with your right to sue letter attached, there's a really good chance those will be extinguished. They will be gone. Gone. You say, but how is that fair? Yeah, there is no fairness standard. This is the law. You elected these people. This is what they did for you. Or, I mean, in fairness, someone elected them a long time ago. Probably not you. You probably were a kid or not even alive yet. But frankly, it doesn't matter. That's the law of the land. So you got to get this filed. Now, can you be pro se in federal court? You can. Should you be pro se in federal court? You absolutely should not. I have videos on this channel helping people who are pro se litigants in federal court, answering their questions. I feel bad when I make those videos because most of those people are actively lying to themselves. They ask questions with partial understanding that is so obvious that I'm like, I open every one of these videos like, listen, you got to get an attorney. You are not grasping the finer points of the mechanics of what you are operating here. This is not going well. I will answer your question because I care about you and I want to help, but you need to go get yourself an attorney. So again, I don't think you should, voiceful, necessarily make your first step filing something in federal court. You should make sure you get something filed in federal court within 90 days. But your first step in terms of what happens now should be that you schedule 3 to 5 consultations, free consultations, do not pay for consultations. Your case is an opportunity for an attorney, not something they should be charging to hear about. You can probably, just right off the bat, discount any attorney who wants to charge you for a consultation. That attorney is probably not a very clever attorney because that attorney, if they were any good, would look at a case and say, well, I could make a lot of money on this case. If I take a third or whatever, 25%, 33%, 40%, whatever it is, I could make a lot of money helping this person. So I want to hear about this case. So I should do this consultation for free, right? So schedule 3 to 5 free consultations. 10 if you want. If you got the time, schedule as many as you can because this is a huge decision. You need to find an attorney to help you. Check all of your local options first before you go to the national firms like ours. Why? Local firms are cheaper because they're there. If you can find a good local firm, it might be a really great deal because unlike our firm, they're not going to have to fly attorneys around the country to help you. They're not going to have to put a bunch of hoity-toity attorneys up in a hotel if you have a trial wherever you are. You can see how my firm might be more expensive than the local options. That is what we do. And we help a lot of people in a lot of places where they don't trust their attorneys, they don't have good options for attorneys. And I feel good about that. But I'm always going to tell folks when they call me from wherever, have you checked your local options first? They're going to be a lot cheaper than us. For good reason, right? Right? They don't have to go to one of their associates like, hey, I got a conference in Peoria. So I need you to leave your super comfy home in the city that you choose to live in, where you're happy, where all your friends and all your family reside. I need you to leave, get on a plane, go through TSA, and go to Peoria, right? That is not a happy associate. That is what they sign up for with our firm. That's what we do. But if there's an attorney in Peoria who's really good at their job and is really good at workplace discrimination and workplace sexual harassment, you would be better served if you too are in Peoria by hiring that Peoria-based star, right? Like that's the woman or the man for you, right? So do that. Check your local options. If you exhaust your local options, if you say, listen, there are no plaintiff side employment attorneys here, or there are no attorneys who aren't conflicted out, or I met with 5 attorneys and no, these are not the people to help me. Okay, fine. Call the national firms. Call the national firms. There's a couple of good ones. I would steer you away. I'm not going to name any names. There's some PI firms right now that are running a lot of ads on podcasts that claim to be like really, really big and have lots of attorneys. That's all true, I believe. I don't know how many of those attorneys are actually employment attorneys, though. So I would urge you maybe look into speaking specifically to one of the national employment law firms and not somebody who's like, we're a personal injury firm, but you can hire us for your employment case. Like that might not be ideal. No names, no identifying characteristics. I don't want that fight. I don't want any fight that I'm not getting paid to fight. So there are a couple of national employment law firms that are good. They're good. and I would investigate all of them and find the right one for you, get counsel, get your case filed, pursue your claims. That is what happens now. I am sorry that the EEOC did not do what you were hoping them to do. You were hoping they would do. That's just dealing with government. This is what government is, right? Now, the nice thing is, when you hire an attorney that you really like, you really trust, that you believe in, you and that attorney are going to have a unity of interest. You're going to be interested in the same thing, which is getting a result for you, because the attorney wants a bigger result for you, hopefully. They want more for you because they're going to take a percentage of every dollar they make you, and that will then also be good for them. So generally speaking, if you're hiring an attorney on a contingency basis, which means for a percentage what they win for you, it'll be nice. You'll have a team, or at least a single attorney, depending on the firm you hire, who will fight for you, who will work with you, who will support you in this endeavor, and that's amazing. Pay attention to things like, are they covering expenses, fronting expenses? What's going on with that? Are you going to get a huge invoice because they spent 40 grand in your case and you're like, whoa, what do you mean? Like, these are conversations to be had, right? Understand everything about the retainer agreement. Read the retainer agreement. So many people don't read the retainer agreement, and I have to like give them home early. Go home, read the retainer agreement. Nope. You can't hire me till you read it. Nope. If you don't come back with 10 questions, I will not represent you. I'm not really joking. I'm that annoying. Because listen, it's easy to just sign a retainer agreement, right? But what you're really doing is entering into a contract that could someday govern a very significant amount of money. I hope for you, right? I hope you're making lots of money, Boyceville. So this agreement should be taken very, very seriously, because if you were going to go out and sign a contract for $500,000 and how that $500,000 is going to get divvied up, you'd probably read it, wouldn't you? Right? So read the retainer agreement. Can we, right? That seems fairly simple. I will check the comments on this video because people are going to have questions. That's fine. I will answer. I will endeavor. No guarantees. I will endeavor to answer those questions. Some of them I'll even make videos for. I'm going to receive some nasty people say wild things. People like rush to the defense of the EEOC sometimes. And okay, listen, that's great. I'm glad they helped you. If they helped you, that makes me happy. They do help some people. There is some small percentage of people that the EEOC will move heaven and earth for. And there are some good employees at the EEOC. I concede both points fully. And I am thrilled whenever that happens. And whenever I run into one of those high-end employees of the EEOC, it makes me happy. Anyways, I digress. Like, comment, subscribe. Helps me to help more people just like you. Remember, almost everybody works. Not everybody wins.